I'm going to have I'm going to give an urgent update right now. I had scheduled today to do two things. I was going to discuss on an aspect of the case of Nnamdi Kanu that I have not done before, and that aspect had to do with the performance of his lawyers. Many people have made a lot of comments. Many people have asked me questions about the performance of Nnamdi Kanu's lawyers since the past 10 years. I didn't want to speak about that for obvious reasons. One, I don't want to put anybody in a negative light, especially the lawyers. I know them. Some of them are my friends, and I didn't want to comment on them. But yesterday, one of them made statements which I found to be very, very troubling and wrong. So that is going to prompt me to say something about those lawyers. I'm going to give you the performance of the lawyers, because I believe that if Nnamdi was properly, if his case was properly managed by the lawyers all the way, this disaster will not occur. The disaster occurred in 2017. From that moment, when he was granted bail, the lawyer involved in that case lost control. And that's when all the terrible things began to happen. That's one thing. But before and then, I was going to also deal with the question people have continued to ask. Many people have asked about what is going on in the rest of the country. Why is it that things get different when it comes to Nigeria? Why is it that it appears that law enforcement in Nigeria is targeted against the Igbos? These questions have been raised. I have tried to push them beside me, but I cannot keep pushing that away for too long. I must at some point begin to discuss about justice in Nigeria, all over Nigeria. And I'm going to begin to ask questions such as, do we have selective enforcement of law in Nigeria? That is the law enforced in a special manner when it affects a particular region. That is a legitimate concern. I'm not going to push it away. I'm not going to say, hey, it doesn't matter. So, but I'm taking these things step by step. We have to deal with what we call real orientation of the Igbo youths. We want the Igbo youths to face reality. After we do that, then we got to get to the other thing and address the issue of justice comprehensively. Now, I want to warn you, all my followers, I want to warn you, I want you to understand that ultimately, I am going to advocate for pardon for Nnamdi Kanu. I'm going to advocate for Nnamdi Kanu to be released. I want to warn you so you don't start misunderstanding my purpose. Okay? I have to take a look comprehensively on Nigerian justice system. I'm going to address the issue of fairness in that system, because this defendant might have committed crimes, yes, but the state has a responsibility to conduct a fair, honest trial. That is correct. If the state fails, let me tell you something you have to understand the way I think and the way the jurisprudence is meant to be. If the defendant is 90% at fault, 95% at fault, and the government is 5% at fault, it will result in the acquittal of the defendant. The error on the part of government is going to ultimately result in the acquittal of the defendant. Why? We hold the government to the highest standard. Government has no excuse to blunder. Government has no reason to compromise the law. The essence of criminal trial, the essence of all trial, is not really about who is acquitted, who is sentenced, who is free. No. The essence of trial is to uphold the law. The law must be upheld. The law must be upheld at any point. If you are a defense lawyer or any lawyer, even if you are the prosecutor, your ultimate goal is not about who goes to prison, who didn't go to prison. No. Your goal is to uphold the law, the sanctity of the law. The law must be upheld, must be respected. So if any party breaches the law, compromises the law, that is ultimately going to undermine the integrity of the process. It is the integrity of the legal process, the integrity of due process that matters in the end. So I have been blaming Nnamdi, I have been blaming IPOB. That is true. I continue to condemn them for their behavior, but ultimately, I'm going to ask the question: has Nigeria done all it should do in the manner it was supposed to do it? Has Nigerian government respected its own laws? Has Nigerian government complied and upheld the rule of law? If, at the end of it, I conclude that Nigeria did not keep to its own laws, that will be a basis for me to demand for the release of Nnamdi. It's not that I support what Nnamdi did. It's not that I support what IPOB did. I will always condemn it. Make no mistake about it. I will always condemn what Nnamdi and IPOB did. However, if Nigerian government is seen to compromise its own law, I will demand for the release of Nnamdi or anybody whatsoever. It doesn't matter who the person is. If anybody is convicted based on obvious error by the state, we're going to do something. And let me tell you something. Because those who don't understand me, they will say, Emeka has changed. Emeka has changed. No. I haven't changed. My position are based on specific events. First and foremost, Nigeria committed one of the biggest blunders you could commit. And that blunder was the rendition. It is wrong. Even though I thought, looking at international practices, extraordinary rendition had never been a basis for any country to forgo a trial of a terrorist suspect. No. So that is why I leaned in the direction of the Supreme Court of Nigeria, which said that even though the rendition occurred, even though rendition was bad, Nnamdi will still stand trial. I lean in that direction, but that doesn't mean that I'm going to close my eyes to all obvious errors on the part of the government. And I say again, for me, it's not a question of whether Nnamdi is perfect. He's not. For me, it's not a question of whether Nnamdi did something bad. Of course he did something bad. It's not a question of whether he did something atrocious, extremely dangerous. Yes, he did. I said that already. It's not a question of whether we need to stop IPOB. No doubt, we need to stop the IPOB. But let me tell you this. If in the analysis I will be making, we determine, and I will tell you how we determine that. If we determine obvious, consistent error on the part of Nigerian government, I'm going to demand and ask for Nnamdi to be released. So bear that in mind. We're going to get there. Let nobody be excited too much, because some people are already clapping for me to say, oh, you support, you oppose Nnamdi Kanu. Yes, I would. But that doesn't mean I will support him staying in prison if Nigerian government had breached its own procedures. We'll get to that point. Now, what I want to do at this moment, which I consider urgent, is on the issue of appeal. I have received many calls from people asking me what I thought about the appeal going on. Now, let me make this clear here. When Nnamdi was being tried, I was making predictions on what could happen. I was making these predictions based on specific things. For instance, you raised the issue of jurisdiction. I told you the court had jurisdiction. You raised the issue of whether he was being tried on a repealed law. I told you no, he was not being tried on a repealed law. Then you raised the issue of whether it was a written law. I told you no, it was a written law. Then you raised the issue of whether the rendition had prevented it. I said no, rendition would not, because of the position of the Supreme Court. Then some of you raised the issue that, oh, he was acquitted by Court of Appeal. I told you no, Court of Appeal judgment is irrelevant because it had been overturned by the Supreme Court. I told you to forget that Court of Appeal judgment. So I was making these predictions because I understood the process. I was basically answering your questions. Now, I told you he will be convicted. I told you he will get life sentence. I told you he will not stay in Kuje prison. And everything I said happened. Many people who don't understand me, they said I'm celebrating Nnamdi's. No, you trivialize the whole thing. You basically reduce me to nothing. If you think that my interest is who went to prison, who didn't go to prison, oh, we got, no. My interest is the integrity of the Nigerian law. The integrity of the law, the sanctity of the law, the rule of law. Was it being kept? Was it being followed? It's like if you are good in soccer and you're watching a soccer match, you can immediately assess the strength of the players. You can look at how strong the defense is. You can look at their midfielders. You can look at their connectivity, their retention power. How good are they? So then you can predict that this team is going to score very soon because you are watching the passes they are making. It doesn't mean you are supporting any team. It doesn't mean you hate the other team. You are just observing the moves the players are making. Their capacity control is great. Their connectivity is great. Their retention power is great. Their coordination is great. The other defense is porous. There are gaps. You already know, based on your experience as a player, that boom, these people are going to score. You predict that this team will win, and the team wins, and people say, oh, you supported that team. Not me. I don't do that. I'm above that. Okay? There is no reason for me to support the government. Nigerian government. No. There's no reason for me to be with them. There's no reason for me to be against Nnamdi. I was concerned about the legal process, and then of course I was concerned about the situation of things in the East. Things have to be controlled there. We have to take control of the situation in the East because it is spiraling into an extremely dangerous, anarchical situation. I want peace and order in the Southeast, but I'm not against anybody. Anybody listening believe that? Why would I be against anybody? Why would I be against it? But I know Nigerian government, one of the most corrupt government in the world. Why will I support it? No. Then I have seen the extreme atrocities committed by the IPOB people. Why would I close my mouth and support? I don't support any of those things. Okay. Now, back to appeal. The more I look, okay, somebody asked me today, because many of you don't know how the appeal system works. Let me explain it to you. At the trial stage, there is one judge. That judge, we call him the trial judge. He's a trier of law and trier of facts. In the Nigerian system, the judge tries the law and tries the facts. However, in the United States, where you have a jury system, the judge tries only the law and the jury tries the fact. That is why in America, it is the jury that will pronounce the suspect or defendant guilty or not guilty, because the jury tries the fact. But the judge tries the law and gives directions to the jury and tell them what they can do, where the evidence they can consider, admissibility of evidence, and all those things are done by the judge because it is a legal question. But on the issue of whether a person is guilty or not, it is by the jury. Okay. That is it. So, but in Nigeria, the judge, we don't have a jury system in Nigeria. So the judge is trier of law and trier of fact. Justice Omotosho will try the law and the facts of this case, and he pronounced Nnamdi guilty. So Now, Nnamdi's lawyers are going to go on appeal. Their first port of call is Court of Appeal. Court of Appeal is where you go from High Court, the first level of appeal. The Court of Appeal, when you get to the appeal stage, only the law is being tried. There is no evidence, witnesses don't testify on Court of Appeal. Appeal is a review process. They review the judgment of the High Court. And the question they ask is this judgment correct based on the law and based on the evidence presented? How do we know the law? The Court of Appeal knows the law. How do we know the evidence presented? They look at the record of proceedings. That's why when you see judges writing, judges are writing, you don't know why they are keeping record of the proceedings. That record will be examined on appeal. So at the appeal stage, you have a panel of 3 judges. Those judges will sit, the 3 of them, will review the law, review the record. They don't call witnesses, no testimony, no new evidence. And based on that, the Court of Appeal would reach a judgment. They will either agree with the trial court or they disagree with trial court, either disagree in whole or in part. One of the things the Court of Appeal will do when they disagree with the trial is they will recommend for a retrial, for the case to be retried because there was error on the part of the judge. And the case will go back and start. However, if the Court of Appeal reaches that decision, one of the parties may still not be satisfied with the Court of Appeal decision. That party not satisfied will go to the Supreme Court. And at the Supreme Court, there are 5 judges. 5 justices will sit and perform the same review. They are now and again reviewing the High Court and the Court of Appeal decision. And at the end of it, they will determine whether the Court of Appeal was right and also whether the High Court was right. Once they determine it, if they say the judgment of the Court of Appeal was good, whatever the Supreme Court says is the final. That's the law. The judgment of the Supreme Court becomes the law of the case. Very simple. Then, that's how it works. That's how the appeal works generally in all cases, not just on the Nnamdi's case. All right. But on the Nnamdi's case, there is a persistent question. I went to bed, I think about these things, I research. I don't just come and start talking to you. It will be disrespectful for me to just come and begin to give you my opinion on what I think, my view of life. No. I research, I check, I analyze, I weigh the options. I am of the view that the judgment of Justice Omotosho will be set aside. Why is it going to be set aside? It's not going to be set aside because Nnamdi didn't do those things. No, that's not why. Nobody's saying that, he did that. All those things that they claim he did, that he didn't do it, that's not why he'll be set aside. In fact, the Court of Appeal will not even go far into the facts of the case because Nnamdi did not put a defense. Nnamdi did not contradict any of the things put there. Really. So the Court of Appeal has no basis to reject the evidence of the prosecution because Nnamdi did not controvert it. However, there is a problem, one persistent problem. And that persistent problem is the manner in which the court foreclosed Nnamdi's defense. The court foreclosed Nnamdi in a spate of 13 days. Why? The court had placed that case on expedited trial. That is, we're going to try this case on a fast track. So the court created a schedule. The court set a time frame within which the trial will be over. It's called the court's own scheduling. It is done by the judge. The judge sets his scheduling. The prosecution must close on this date, defense will close on this date. That is what the judge did. It is his own schedule. When he put that scheduling, Nnamdi had lawyers. So when Nnamdi fired his lawyers, which the court admitted he has rights to do, and chose to defend himself, which the court admitted he had right to do, if that was the case, the court must give him adequate time, adequate opportunity to enter his defense. But apparently, if you noticed, on the 24th of October, Justice Omotosho said to Nnamdi, okay, if you fire them, fine, continue with your defense, because today was the day the defense was to open. Nnamdi protested. He said, no, continue. It was the senior lawyers who had been fired by Nnamdi who said, no, my lord, please allow him time. And he allowed him till Monday. So it signaled that this judge wanted to maintain his calendar, that scheduling he had set before. He wanted to stick to it despite the sudden major development that the defendant fired his lawyers and took on his own defense. That, for me, is a fatal error, because it raises the question of whether Nnamdi had been given adequate opportunity to defend himself. Has the defendant been given adequate opportunity to defend himself? Even a new lawyer coming into a case, criminal trial, will need more than 13 days to take over a defense. Assuming Nnamdi had fired his lawyers and hired a new lawyer, that new lawyer cannot start immediately. That new lawyer will ask, my lord, I need time. I need time to review the files. I need time to speak to witnesses. I need time to assess things. In fact, I need to spend time with this defendant. And this defendant, my lord, is incarcerated at the DSS. It's not as if I can call him in my office and spend the entire night preparing him. No, he's in DSS. Access to him is limited. Therefore, we need time. I need a week with him. That's what I would tell the judge. I need 1 week with the man. I need 2 weeks with the witnesses who are planning to come. I need 2 weeks to review everything and prepare for defense. So, when Justice Omotosho was trying to stick to his trial schedule, that was an error. That was an error. Especially because Nnamdi had asked for 90 days. When he said 90 days, the court would have said, 90 days is too long, Mr. Kanu. We are going to give you probably 1 month, probably 2 months. Or the court would have asked him, the court will go into details. Why do you need 90 days? Why? Then Nnamdi will explain so that the court can make a determination, informed determination whether he needed more time or not. The fact that the court didn't delve into that, the court didn't want to hear any argument, any explanation as to why he needed 90 days. The court basically said, no, you gotta go ahead. And by the way, even the 13 days given to Nnamdi was not given to him in a straight format. The court could have said, hey, I'm giving you 2 weeks. Assuming Justice Omotosho had said, listen, because you changed your lawyers, I'm giving you 2 weeks. It will make sense. But the judge didn't do that. The judge gave him 1 day, 3 days, then 3 days and 4 days. Giving it to him in that manner didn't give him an opportunity to assess how much time he really had to put on his defense. So now, somebody can argue that without sufficient time to prepare for his defense, Nnamdi had no choice than to give up his defense. And by the way, he didn't quite give up his defense, if you noticed. He didn't say, no, I have no defense. That's not what he said. The court foreclosed him. The court just said, okay, henceforth, boom, you are stopped from defending yourself. You are deemed to have waived it. Deemed to have waived it. Not that he waived it. So, that alone will be a basis for his conviction to be set aside. And when it is set aside, the court is going to order a retrial. Now, let me warn you. This is weird because Nnamdi supporters will be very happy now that I said that the judgment to be set aside. I am 90% sure the judgment to be set aside. But let me tell you something. Do not rejoice. Nnamdi Kanu, do not rejoice. Because even if they retry the case, Nnamdi will still be convicted because of the overwhelming evidence. The evidence will remain there. The reason they're going to set the judgment of Omotosho aside is not because Nnamdi is innocent. No. It is because that the court didn't give him adequate time to prepare for his defense in view of the fact that he just fired his lawyers. He is a layman, not a lawyer. He fired his lawyers. He's a layman, not a lawyer. The record is extensive record, and he wasn't even free. He was incarcerated. All these factors would mean that Nnamdi should have more time than would have been given an ordinary person. Nnamdi should have more time than would have been given to a lawyer. Nnamdi needed more time to prepare his defense than a lawyer would need to prepare his defense. So giving him 13 days, of those 13 days, four are weekends. There were 2 weekends in between. So there was a weekend that started on the 24th to 26th. Then there was the other weekend. So given that as it was, it's not sufficient. Indeed, Nnamdi's conduct after he took over his case should have convinced the court that he didn't know the law. He was blundering all over the places, remaking applications, filing motions that are useless motions of no effect, repeating what. So that was indeed a warning to the judge that this man doesn't know the law. So he needs to have more time to prepare his defense. So that is it. But this is what will happen. If a case is reopened for trial, a new trial, that means Nnamdi will take his plea again. They will read those charges again to him. And then he will have another opportunity to file preliminary objections saying that it is a repealed law. And the judge will overrule those objections and proceed with trial. And then the prosecution will come out and produce this same evidence. This same evidence, this damaging evidence, the Gulag thing. But this time, Nnamdi will be able to defend. And if Nnamdi defend, represented by lawyers, he will not have an outburst in court. He will not insult the judges. He will be very calm like ice water. And his lawyers will make that argument. He will be convicted. But if convicted, it will be on a lighter. The judge will say something nicer about him. The judge will not call him a tyrant. The judge will not do all those things because he would have comported himself well. But now, this is what I think will happen. If you start a new trial in the case, which is going to take time, the pressure for Nnamdi's release, political solution, will increase. Ultimately, it will be resolved politically. So this is all about, I'm going to tell you about appeal. When I get into subsequent episodes, maybe tomorrow, when I get to the issue of why Nnamdi should be released, it is because I'm looking for a political solution. What happened was bad. The killings were bad. But it had almost taken the proportion of war, the nature of war. Even though people will say that when there is war, people could be tried and killed, as happened in the Second World War. German commanders were tried and killed. Japanese were tried and killed. We knew that. However, political solution is going to be the way for Nigeria. Because there are so many problems that we are seeing. First, the Nigerian security forces did not do a good job. They compromised much of this. They failed to do what they needed to do. As a result, violence was spreading. 2, you have millions of people who believe in Nnamdi, who are following him. Even if you think they're stupid, you can't ignore them. It is dangerous to ignore millions of supporters. That means you are sowing a seed for future violence and future instability. So Nigerian government must pursue a holistic process. But that holistic process must, as I said earlier, it must require comprehensive accounting. We need to know all the people that died. We need to know how they were killed. And we need to make adequate compensation to their families so that there will be justice for the victims, justice for the community, and peace and order. Taking Nnamdi, locking him up, and saying the case is won over is dumb. The case is not won. The struggle is not won. Things are going to get worse. Things may get worse. So, Nigerian government must do more than just locking up Nnamdi Kanu. They must understand that there are millions of people affected. We watched the videos of Nnamdi where he was saying he was going to get the head of Buhari. He had a lot of people there. Did you hear them cheering him? They cheered. Thousands of people present cheered. Nobody said what? They cheered. 2, when you saw him saying that he told the Obasanjo he had instructed IPOB to kill all his lineage one day once, they clapped for him. So if you take Nnamdi, what about those clapping for him? You must start a process of education and orientation to get an understanding. They open a dialogue. We want a situation where people will not be clapping when they hear that somebody's going to kill relatives of somebody. So, and don't forget that at the moment when Nnamdi was threatening to go and bring the head of, he said, I'm going to Abuja to bring the head of Buhari. In other words, what was he going to do in Abuja? He was going to attend court to continue his criminal trial. So at that time, Nnamdi had a lawyer. Who was his lawyer? Who was advising him? Did his lawyer tell him he couldn't make such statements? If the lawyer knew his work, I'm going to tell you, don't do this stuff, man. If you do it, I will leave. I will remain your lawyer. So, but he did it. Nothing happened. Then he threatened the Obasanjo's family. Nothing happened. He went around threatening people in clear violation of terms of bail. These were violation of the conditions of bail just granted to him, and he was on bail. So if he was receiving proper guidance and proper advice by counsel, he will not do those things. So the case is deep and complicated. It takes a very sound, advanced legal mind to sort these things out. Okay? Thank you so much. I had to give you this update because it's urgent. I'm now going to have my shower and prepare. I haven't even had my breakfast. Okay? I was preparing to explain to you the performance of his lawyers, which I think were very terrible and disastrous. Okay? I will still do that. Maybe not today, maybe tomorrow. I could get into it, and I'm going to get into the issue of how the Northerners have dealt with insurgency. This perception that Nigerian law is enforced in a special manner. Okay? And this idea that Nnamdi should be kept in Sokoto, that is a very troubling idea. Because you know what it does? It reinforces that perception of persecution. Why are you taking him to Sokoto? Why do you think Sokoto is a better place to keep him than anywhere else? What made Sokoto special? It is because people say, oh, he can be anywhere in Nigeria. Of course, you know, that's not a fair argument. If he could be anywhere in Nigeria, then why is he not in Lagos? If he could be detained anywhere in Nigeria, why not in Port Harcourt? That is the question of any moment, the situation that arises when somebody abuses discretion. Abuse of discretion. You know what it means? Now, let me explain to you what the abuse of discretion is. If you are not a lawyer, you understand it. Let us say I am to sweep the entire room. I have, let's say there's a hall here. I'm to sweep the hall. Yes, I have right to start anywhere I like. That's my discretion where I start the sweeping. Where I put the brush, the broom out. It's my discretion. I'm supposed to clean the whole room. I can start anywhere. Let us say you are sitting in one corner of that hall. And I started cleaning right from your feet. I come straight to your feet and say, raise your leg, and I start doing it. So it is an abuse of discretion. Yes, I have right to start anywhere I like, including where you sit. But the fact that I chose to ignore all the other places I could start the sweeping and came to your feet to push you around, that's an abuse of discretion. Yes, Nigeria has right to detain a convicted inmate anywhere they like. But that argument defeats itself. Because if they have right to detain him anywhere they like, then why did you choose Sokoto? You must have a reason why you rejected Lagos. So, I want you, my audience who follow me, please try to understand. I don't take sides. I'm not sentimental. I am looking at the law. And I'm using this opportunity to explain to you things you didn't know. Why? What do I need to achieve? One thing. I want you to go home and think. I want you, at the end of this episode, to start thinking. If I can cause you to think, then I have achieved my purpose. I'm not interested in where you ended up your thinking, but I want you to be thinking. Don't take these things for granted. Probe them. Analyze them. Ask questions. Many of you are sending me questions. Many of you are sending me information of atrocities committed by IPOB. I know. And I condemn those atrocities. But you see, we have something more serious here. Something bigger than any specific case. Okay? Thank you so much, and God bless you. Enjoy your Sunday. Possibly, we will have another episode today. But if not, I've got a whole lot of work to do because this is Sunday. We're entering into a new week, and I haven't even had my breakfast. What time is it? Okay, the time here is 3:23 p.m. 3:23 p.m. I haven't had a breakfast. All I have had is my coffee. Okay, so I skip breakfast. I skip lunch. Let me make sure I catch dinner. Okay? Thank you so much for those of you who come here. Now, let me say for those of you who attack me, brothers and sisters, my fellow Igbos, don't feel angry. Don't feel angry. I'm doing what I have to do. I am helping you gain a new perspective. I'm helping you see the branches to this tree. It is complex. Pay attention. My goal is justice, comprehensive justice, holistic justice for Nigerians to heal, for us to move forward, for us to eliminate these divisions that held us back, for us to stop thinking that our enemies are people of the other tribe. No. Our enemies are within us. We have to make peace within us. We have to seek reconciliation. This is 2025. This is not 1967. Thank you and God bless.
In the heart of the city where stories unfold, Ginger Media TV shining bright and bold, bringing news from the corners of the globe, connects us together no matter the road. Oh, just rise, hear the voices roar, unity and diversity, together we